not be taken up today, I think, your lord.
I don't know why it has been not today. 5 and 6 not today. 7. Not today করে রাখুন এটা কিরম ভাবে লিখেছে এটা not today করুন 9 is those matter, no?
My lord, 8 is for the petitioner and
I am
his client.
making it not today.
দুটো জাজমেন্ট অনন্ত মিত্র স্যার দিতে বলেছেন দিয়ে দেবো My lord, before starting the argument of Mr. Bhattacharjee, Mr. Mitra told me over phone that he needs two judgment. My lord, I am relying upon those two judgment, my lord. My lord, one, my lord, 1997 4 SCC.
Just a minute, sir. Nineteen
1997 4 SCC 177 177
1997 4 SCC
177
177.
paragraph 6 and 7. Madam, on the point of mistake, Madam Lordship, paragraph 6 and 7.
You are in petitioner. In it's not about the
Matter relating to pay.
Sir, wait.
My lord.
I am little bit
845.
I'm little bit handicapped because of my absence of my regular issue. Your WPA is 845 or 2025? No.
My lord, 845. পাখাগুলো বন্ধ আমি করে দিচ্ছি এটা হয়ে
Yes, sir.
6-7. Another judgment, my lord. My lord, this honorable court to division bench 2004 to CHN
2004 volume 2
CHN 606 paragraph 22-23. এটা দিয়ে দিন তো।
দাও। কি হলো গো? Yes.
My lord, but this is my submission.
Yes, Mr. Bhattacharya. In which matter you are appearing in WPA number?
I am in WPA number 1436.
1436 of 2000.
25.
এই ফাইলটা বার করুন 1436 of 2025. দেখো এই দেখুন ওই উপরে না নাম্বার 9টা লেখা আছে নাম্বার 9. I'm a bit handicapped today because my regular issue has not come.
Oh, then it's very difficult to search.
Really difficult.
আস্তে আস্তে সময় নিয়ে দেখুন।
দেখুন উপরে পেন্সিল দিয়ে বা পেন দিয়ে 9 নাম্বারটা লেখা আছে. Very difficult.
And because it is so many,
Because that gentleman is acquainted with the files, no? He's a new one.
completely understand. It is like Mr. Bhattacharya is not having his
Junior.
junior or the
Law
even or the clerk also. Same.
Clark.
Yes,
Junior থেকে ক্লার্কটা বেশি।
we work as a team basically.
Absolutely. Because 9টা লেখা আছে দেখো 9 আমি মার্ক করে রেখেছি.
পেয়েছেন? হ্যাঁ, আস্তে আস্তে তাড়াহুড়ো করে ফাইলটা ছিঁড়বে।
এটা লাগবে না অর্ডার বুক ওইটা দিন.
কভারটা ছিঁড়ে গেছে।
আর 1 নম্বর ফাইলটা দাও. 1 নম্বর যেখানে অরিজিনাল রিট পিটিশন মানে এটা রয়েছে 1 নম্বর ফাইলটা মানে হচ্ছে আর যেখানে কম্পোজিট এফিডেভিট অপোজিশনটা রয়েছে ওই ফাইলটা লাগবে. ওটার নাম্বার হচ্ছে WPA 24588 of 2024. ওইটা লিড কেস. দেখুন উপরে লেখা আছে 1 নম্বর বলে. পেয়েছেন? ওটা সামনে রাখুন. আর আপনি ওই যে জাজ একটা দেখুন লয়ার
Your Lordship probably has been well now been acquainted with the basic facts.
absolutely.
Therefore, I will not trouble so for the factual aspect is concerned, excepting pointing out not the my grievance and my lucas that will appear from paragraph 8 and 9. That's all. So far, my factual aspect is concerned that I am selected by ministerial issuance of appointment letter has been stayed.
Paragraph 8 and 9.
Paragraph 8.
You are the sole writ petitioner or you have a yes,
No, we have number of petitioners.
number of
Who are
petitioners?
successful. Let's read out. Paragraph 5. Your petitioner state that
Give me a second, sir. Yes, sir. Paragraph 5.
yes, petitioners appeared in the first state level selection test for the post of Group D. West Bengal Madrasa Commission conducted the preliminary screening test of the first SLST Group D for a total number of 70,978 candidates, which was held on November 28, 2010. Subsequently conducted the written test for first SLST Group D on May 29 for the qualified candidates. There was a total of 24,000 candidates initially, including the petitioners. Then, petitioners state that the commission published a list of 73,000 and odd who appeared and qualified the preliminary screening test, and a list of 24 and odd candidates initially, including the petitioners who appeared at the written test held on May 29, 2011. Then Lordship may skip over the next paragraph, then paragraph 8.
So you participated in 2011 written test. Understand?
Now the petitioner state paragraph 8.
Give me a second. Give me a second, sir.
There's a total number of candidates who are called for the personality.
Give me a second, sir.
Now, my lord, the
Mrs. Bhattacharya, please let me note it.
sorry.
Yes.
Now, my lord, as I have been following, my lord, I understand the point is whether there can be two different tests for the purpose of selection and final appointment.
So,
But-
Mr. Bhattacharya, so far your clients are concerned.
My
That
client
is the
started with first-
read petitioners in WPA 1436 are concerned. The basic difference is that with the other petitioners, whom Mr. Mitra represented, but your clients appeared in the first written test, and probably you have been selected in the final merit list.
I appeared in the first test. I have been selected in the final merit list, which is called combined merit list. Because there cannot be any difficulty in giving effect to combined merit list. That is not my submission principally. And for that purpose, I will take your lordship, Lord, for a glance to the orders passed by this court from time to time, whether there is any stay granted by this court from proceeding in accordance with the recruitment rules, which is in compliance with Article 14 and 16 of the Constitution.
Let me have a look to your prayer once.
Yes. My prayers are, my lord, very specific. To
Respondent
issue letter of appointment.
to give appointments. So you have been complied even in Bhaivavosi also.
Lord, I was just about to get the appointment letter, then my lord, the interim order came.
Very
Now,
good.
why the interim order? My lord will kindly take the trouble to go through the orders passed by this court from time to time, and ultimately this matter also went up to the Honorable Supreme Court. I shall pass that.
This matter.
Yes, similar matter. From the order dated 12th of September.
এবারে অর্ডার বুকটা লাগবে আমার অর্ডার বুকটা দিন ওই যেটা আর কি কম্বাইন্ডলি হচ্ছিল অর্ডার বুকটা দিন না এটা না অর্ডার বুক যেটা আফটার সব কম্পাইলেশন আমার পরে যেখানে অর্ডার বুকটা হচ্ছিল অর্ডারটা
আমার তো দাম 10 কেজি আর কপি মার্ক কপি থাকে দে না মার্ক নেই তো just prepared a bunch for your lordship consideration. এইটা দিয়ে অসব দিন তাহলেই হবে, তারপর আপনার খুঁজে বার করুন ফাইল। My lord, kindly turn to page 7 of this Lord Punch, the order dated 12th of September 2023.
এটা তো এখানেই আছে এইটা দিন লাস্টে যেটা কম্পোজিট অর্ডার বুক হচ্ছিল না সৌরভ একটু দেখিয়ে দাও না একটু যেতে মনে হয় পেয়ে যাও ইউ আর রেফারিং টু
12th of September 2023 order.
12 passed by the division bench.
Since lordship is well aware of the facts, I am not really repeating. Just
No,
trying to be concise to the point. This 12th September order, I believe, is being used to get the selection process initiated.
Yes,
That may I be permitted to place it, my lord?
yes.
Applicant, these are the applications taken out by the appellants as well as the non-parties to the instant appeal seeking a modification of the final order dated 4th of February 2020 and impleading as party in the application filed in connection with the instant appeal after the final order. The instant appeal was filed assailing an order of the single bench dated 23rd of July 2018, where the writ petition was filed by the respondent number 1, seeking a mandamus commanding the appellants to publish the result of the recruitment examination concerning Group D. That here the appellant was the Madrasa Commission. That was the basic prayer in the writ petition. The first paragraph of the said order reveals that the single bench directed the learned advocate representing the commission to submit a report, which in fact was done on the said date. In the said report, it was indicated that the result of the written examination of state level selection Group D is yet to be published. Now, kindly note this one. Result of the written examination yet to be published. As the instruction has been sought by the Commission from the Minority Affairs and Madrasa Education Department, and till date, no such instruction was given by the Commission. The single bench, after considering the relevant rules applicable in this regard, categorically held that the Rule 17, as relied upon by the Commission, does show that where the written test has been held, such instructions are required. Ultimately, the single bench was of the view that since the considerable progress has already been made in the recruitment of Group D, the entire exercise is required to be completed and directed the Commission to complete the entire exercise within 14 days. Now, this is a direction of the court which only directs for publication of result. It doesn't say that if there is any legal difficulty in publishing result, still it to be done. The court doesn't do so normally. The Commission filed the instant appeal, and the said appeal was disposed of, declining to interfere with the order of the single bench on merit, but held that the time indicated in the order by the single bench for completion of the entire exercise is too scanty, and therefore the division bench modified the order to the extent that instead of 14 days, the Commission shall comply the direction within 6 months from the said date. The order of the division bench dated 4th February 2020 is the final order disposing of the mandamus appeal as well as the applications pending therein, and therefore the court lost session of the matter and thus become functus officio. Subsequently, an application for extension of time. Nothing these applications relates to merit, since the division bench says that the on merit issue was decided, but division bench was worried about the scanty time given to the Commission. Subsequently, application for extension of time is taken out by the appellant, stating that immediately after passing the order, there was a complete lockdown declared by the government because of the pandemic, so and so. I am not troubling my lord. Then there is no dispute to the fact that while disposing of the instant appeal on 4th of February 2020, the court directed the compliance of an order passed by the single bench to be completed within 6 months from the month of March 2020. There was a complete disruption, but I again will not skip about this paragraph, which is really narration of pandemic. Then at the time of hearing of the instant application, several other issues are raised by the appellants, impinging upon the merit of the order of the single bench as well as the appellate court. It is submitted that subsequently certain illegalities and irregularities have been detected, and therefore the court should reopen the entire issue, but till date no application has been taken out, and the only application which is pending before us is the extension of time to complete the exercise. So for the implement, I am not troubling my lord. Therefore, the appeal court, by this order, my lord, refused to entertain the basic merit which was decided, and also refused to entertain other matter except granting time. This order was challenged before the Honorable Supreme Court.
It was challenged.
Yes, by a lord group of unsuccessful candidates. That order I just handing up to your lordship, lord. Finally, the special leave was order dated 12th of September 2023 at the top. I got it.
Yes, sir.
Kindly see that at the top.
First page or third page? First page or third page?
No, not first page, second page.
Second.
Third page. Third page. Third page.
Third page, yes.
At the very top, you will notice special leave petition, diary number so and so. Then, arising out of impugned final judgment and order dated 12th of September 2023 in Matt so and so. The order we just now have placed before Lordship.
Special leave dismissed.
Yes. Not only this was on merit. Where I place this without paragraph. Application seeking permission to file the special leave petition is granted. Therefore, the SLP was granted. This is very important indication that it is finality, not outright dismiss exercising power of Article 136. Delay condoned. Then, having heard learned senior counsel for the petitioner at length and after carefully perusing the material placed on record, we are not inclined to interfere with the impugned order passed by the High Court. This is dismissal on merit. And now, what were the points raised?
Mr. Bhattacharya, give me a second.
Yes. SLP petition. Can I?
Yes, Mr. Bhattacharya.
Unmarked কিছু নেই I just will now hand up to your lordship the special leave petition. That is also very important.
ওটা ওদিকে বাঁদিকে লিখুন এইখানটায় WPA 1436 of 2025 petitioners বলে। এই দেখুন এরকম ভাবে লিখুন, এটা দেখে লিখুন যেমন ভাবে লিখেছি, যেখানে লিখেছি ওই রকম ভাবে বাঁদিকটা লিখুন।
Now, after the list of dates, the bunch is also stitched with list of dates. After the list of dates, my lord will find the special the petition and the grounds. I just will not place the relevant grounds. Others are not important.
You are referring which portion?
But I will be referring to, my lord, can you see this portion? After the list of dates bunches, can you skip over the list of date bunch? Then the SLP petition is the next.
Yes.
Now I just place below the grounds. Your lordship is well aware. This is the format in the special petition. First I have to say the grounds of challenge.
Paragraph 5.
Nice. Paragraph 5.
Give me a second. Yes.
Now I'm just not referring to the ground, which according to me is very important. Kindly come to below
This is SLP at the instance of whom?
some of the unsuccessful candidates.
Achha.
Like here, my lord, I am relieved that the unsuccessful candidates will not have argued the matter at length in detail.
Very good, sir.
Ground G, because the Honorable High Court of Calcutta disposed of the writ petition with the direction that, I got it, Commission shall intimate to the writ petitioner the result of the evaluation of the answer script, and if the said candidate had qualified, then to prepare the panel in terms of Rule 18 of the said rules, and they shall grant him appointment in case he stands qualified. It was further clarified that said exercise was to be done within a period of 14 days. This was one of the ground challenge. Then the next are not very important. Then kindly come to P, capital P.
Yes.
Because while filing a reply in the writ petition preferred by the petitioner herein before the Honorable High Court of Calcutta, the respondent commissioner stated that, quote, while undertaking the process of evaluation, several technical errors which were serious in nature had occurred, which required de novo evaluation of the entire examination process of Group D posts. The commission stated that on prima facie inquiry, 26,000 and odd candidates were declared to be qualified in the screening test. And these qualified candidates thereafter appeared in the written examination for a Group D post held on such and such. It was submitted by the commission that actually a total 1 lakh and odd candidates had qualified the screening test and should have ideally undertaken the written examination. The commission stated that a total number of 74,000 odd candidates had been left out of the written examination, and they hoped to undertake a policy decision in regard to the present recruitment process. The commission suggested that either they could make the qualified candidates from the screening test, including the ones who already gave the said test on 29th May 2011, retake the written examination, or they would want to scrap the entire process of recruitment altogether and conduct fresh examination. The commission stated they needed a further period of 6 months for thorough re-examination. The process of recruitment was done. This was the specific point which was challenged if the Supreme Court, the commission cannot proceed with that. Then kindly come to T.
I believe this ground, there is a quote unquote portion has been taken from the application of the commission. I believe so.
Right, so. Because that was the application made here. They have quoted. They wanted to impress upon the Supreme Court that in view of that, nothing can be done. The order of the division bench, that single bench, that complete the process and hand over the appointment should be set at naught. That was their prayer before the Supreme Court. And these are the grounds. Kindly now turn to me the T.
No, before the Supreme Court, before the Honorable Supreme Court, the grounds taken by these petitioners that the division bench has failed to visualize the true spirit of the application of the commission for holding.
Said that the single bench directed that you issue appointment letter. Division bench also reaffirmed that. Reaffirmed even on the face of the commission statement that they have to take 2 examinations. That is the quotation. That was the ground they approached, saying, therefore, the entire selection is set at naught. The Supreme Court said, no, after hearing the petitions and said,
No, before the Honorable Supreme Court, that these petitioners have approached the Supreme Court
seeking,
stating inter alia that because of the stand of the commission, the division bench ought to have modified the order. Ought to have modified the order as has been passed while disposing the appeal. Am I correct?
No. The division bench on merit had upheld the order of the single judge.
Yes.
What was the direction of the single judge? That you
To
should
publish the result.
Now they say, thereafter the commission had approached the division bench, giving these reasons that why.
Which has been negative by the division bench.
Negative by division bench. And the negativity of the division bench was challenged.
Negativity of the challenge was challenged because
these
petitioners' interests are going to be hampered.
Not my petitioner.
No, these petitioners. The petitioners before the Honorable Supreme Court in SLP. Their interests were going to be hampered by the order of the division bench.
Their interest is hampered because division bench had set aside the order in view of the affidavit of the commission. Then they would have been entitled to contest.
Sir, to be very precise, I believe these petitioners, not your clients.
I mean,
the petitioners before the Honorable Supreme Court were found to be not successful in the written test dated 29/5/2011.
No, not only that. They were also challenging that the division, before the division bench commission wanted to have review of the merit on because of these allegations. Kindly come to order of 12th September once again. 12th September order, the division bench says, we have just now placed, Your Lordship. Kindly come to Milord the punch I had handed over the Lordship, Milord, page 9. 8-9. Well, 9 is one G.
And I will look from the composite affidavit anyway. You show me the portion.
Yes, kindly come. I am just reading the portion, Milord, of 12th September 23 order. The third page of the order.
Third page of the order. Very good.
Third page of the order, Milord. At the bottom,
Yes, sir.
at the time of hearing of the instant application. Got it? Several other issues are raised by the appellants, that is commission, impinging upon the merit of the order of the single bench, as well as appellate court. It is submitted that subsequent certain illegalities and irregularities have been detected. Therefore, the court should reopen the entire issue. But till date, no application has been taken out, and on application which is pending before us is extension of time.
Exactly, sir. What I intend to say. Try to listen me and whether please let me know whether I correctly understood or not. So far as the read petitioners, so far as the petitioners before the Honorable Supreme Court in SLP is concerned, they are definitely unsuccessful in the written test held on 29/5/2011. Am I correct, sir? Now they have
Just a minute. Did they participate? Their petitioner chilo? 29th 11. No.
In the year 2000.
I am just checking it. Then Lordship kindly proceed.
no. I believe your client stand a little bit different from Mr. Mitro's client.
So, Lord, my stand is little bit different in the sense I say that I in any way I am successful.
Absolutely, your position is better than the position of the clients of Mr. Mitro.
I am on a higher pedestal.
Absolutely, because you were found to be successful in
11.
29/5/2011. Now, your contention is that taking note of the fact that the commission's subsequent stand was not considered favorably by the division bench while passing the order dated 12/9/2023, some unsuccessful candidates approached the Honorable Supreme Court because they were found to be not successful in 29/5/2011 examination, be the either on merit or on account of alleged irregularities, whatever may be. Ultimately,
They were not successful.
They were not successful. Now I believe these petitioners want to scrap the entire process.
Yes.
Entire process, because they are on account of their unsuccessfulness.
They wanted to take advantage of
They wanted to take advantage of that. That I intend to.
Absolutely right.
So your clients are in a higher footing.
Higher pedestal. My clients, my lord, claim to get appointment in no way can be interfered with. There's no doubt of that. I'm showing my lord.
I'll consider later on. Yes, sir. Mr. Bhattacharya, so far clause T is concerned, what would be your submission?
May I read out not? Because the right before the expiry of the period of 6 months, the respondent commission
You are reading which portion, sir?
Paragraph T.
Clause T. There you have
Ground
T.
T rather.
Oh,
I
I'm
have
sorry.
placed ground P, now I am T.
Yes, sir. T.
Because the right before the expiry of the period of 6 months, the respondent commission has moved an application in the disposed of case stating that they would further extension of time for another 6 months. The respondent commission has taken a policy decision that they would want to reconduct the entire process all over again by including 74,000 who were left out by adding them together with the already qualified being so and so. I come to this group, qualified 26,000. They further indicated that they were in the process of finalizing the exam centers and have also sought report from the district
The
magistrate. regarding-
respondent commission has taken a policy that they would want to reconduct the entire process by including eligible candidates who have left out by adding them together with the already qualified candidates of 26,445 in number. They further they were in the process. These 26,445 is the qualified candidates in the preliminary in the screening test or in the written test.
Finally, after written test.
Written test. So then your client comes in this this paragraph.
My clients in the second group.
So, Mr. Bhattacharya, I believe it would be your contention that since your clients have been qualified in the screening test, since your clients have already been qualified in the written test on 29/5/2011, and since your clients have found place in the successful candidates who have been called for vivacy, and since your clients have already found to be successful in the vivacy and have been they have been placed in the panel, by this way or that way, their selection cannot be touched.
Number one.
That is, I believe, your
That
contention.
is the fundamental point. Malad is absolutely right.
Because for the sake of argument, if I negative the contention of Mr. Dhar, and if I hold that the commission has no authority or was to hold the second written test, your position remains unaltered because of the fact you are found to be successful in all categories. That is your.
That's my point.
Next question then arises whether for the sake of argument, if I negative the contention of Mr. Dhar's client, whether definitely then the benchmark will change, whether that will affect your client.
No. Number one, no. And number two, Milord, for abundant question, Milord, I would try to, Milord, pursue.
Mr. Mojumdar and Mr. Sami will answer to this point also.
Milord, I would
Yes. 11 and successful.
no, Milord. Therefore, my further argument would be, Milord,
Very good.
my further argument that the second test, which is so-called second test, is impugned. That prayer also negative by the Supreme Court. That's why I'm pressing this. The petition which was filed before the Supreme Court challenging 12 September order is that the division bench should not have accepted the merit conclusion by the learned single judge because of subsequent development of irregularities which was detected by the commission. Therefore, the second test is also not permissible. That was argued, and Supreme Court, having considered, negated that. Thereby, Supreme Court has permitted that the even second test is permissible. This is the contention before
Supreme Court has negated the
negated because that was
negated the holding of the second written test.
no negated the prayer of or not holding the second test. Kindly come to paragraph 12. W, sorry. W.
W. Yes.
Because no explanation has been offered by the respondent commission till date as to what happened to the candidature of 26,000 candidates who stood qualified in 2011. The Commission has constantly sought time to compile and finalize the result. However, at this stage, wherein 3 extensions have been granted, now have come up with a new plan to conduct the examinations all over again, thus restarting the entire process for which the Honorable High Court Calcutta had not granted them any leave as such. That was their contention. And then kindly come to me, Lord. Lord, double next page. Z. It's an important double A, because the policy decision taken by the Commission to reconduct the entire examination will have detrimental impact on the lives of the petitioners who are already in a very bad position due to acts of the Commission. This is a specific point. Then poor, forget about that. Now kindly come to Lord, the pleadings.
How do I work, sir, without page number, with the voluminous file?
These documents, they have been really have been able to gather piecemeal. আমার দিস না তোর ওই এখানে কোথায়
পুলিশ ওয়েব থেকে আরম্ভ হচ্ছে
মিলবে না
এটা মোস্ট রেসপেক্ট পুলিশ ওয়েব পাঠার নাম্বার দিয়ে নিয়েছে মোস্ট রেসপেক্ট পুলিশ ওয়েব
সবই তো 4টে অ্যাপ্লিকেশন হয়েছে yes now it kindly takes up the application of the seeking permission to file special petition ওখানে তো অ্যাজিনেশন করা নেই তো দেখবি কি আরে এটা করে দিবি না কোথায় কাছে দিচ্ছিস Well, kindly turn to me, Lord. I do not know whether the after me, Lord, the grounds. The next page is the SLP petition.
Yes.
Kindly come to paragraph 10 of the petition. Well, got it. That this is 2 pages after the grounds.
Got it, sir. Got it.
Yes. Now kindly come to paragraph 10. Paragraph 10. The Commission had thereafter sought time from the Honorable Court on the pretext that the non-checking of answer scripts was due to voluminous answer scripts. The respondents thereafter sought a further period of 6 months' time to complete the exercise, wherein the examinations were held in the year 2010. The Honorable High Court Calcutta had, after listening to both parties before it granted a further period of 6 months' time for the completion of the evaluation of answer scripts. The Respondent Commission had on other occasions stated that while undertaking the process of evaluation, several technical errors which were serious in nature had occurred, which required de novo evaluation of the entire examination process. The Commission stated that on prima facie inquiry, so-and-so were declared to be qualified in the screening test. And these qualified candidates thereafter appeared in the written examination for Group D post held on so-and-so. It was submitted by the Commission that actually a total of 1 lakh and odd candidates had qualified the screening test and should have ideally undertaken the written examination. The Commission stated that a total number of 74,000 have been left out the written examination. They hope to undertake a policy decision in regard to the present.
So, Mr. Bhattacharya, these pleadings,
Ah,
these
yeah.
prayers were placed before the Honorable Supreme Court in the SLP. It was not considered.
It was considered and Supreme Court rejected. Kindly see the
No,
order.
no, it was, what I intend to say, that the
It
Supreme
did
Court
not
while
appeal to
disposing,
Honorable Supreme Court.
huh?
It did not appeal to the Supreme Court judicial consent,
Absolutely.
and they rejected the prayers. Therefore, the challenge to the order of the division bench, which was affirmed by the single bench, challenge was thrown that they ought to have not been allowed to hold the second exam.
And the commission was a party to the SLP.
Yes, yes, of course so. Now, but this being the position, order of 12th September 2003,
Has reached finality.
as it is the finality, and the points which were agitated that they cannot hold second examination was also negated by the Supreme Court. Now I will take your lordship, Milord, through the rules to show even the rules permit. Kindly, Milord, takes up the recruitment rules. Then I shall.
রাখুন। So, Mr. Bhattacharya, before going to that, I believe, please listen to me. I don't know whether you have been properly, because you were not at that material time, you were not before this court when the argument was going on.
Yes.
Be there as it may, I believe your clients are, your juniors have briefed you. Very good. Sir, give me a second, sir. So, Mr. Bhattacharya, I want to know your specific stand. Your specific stand. So far, the submission of Mr. Thor is concerned, that the observation of the division bench in those orders, more specifically the order dated 12/9/2023 and the subsequent order, is a mere obiter, and that is not the ratio decidendi, which Mr. Mitra also in course of his argument also supports this. I believe you are taking a contrary stand.
No.
Because of this stand.
No, I would say with greater respect, division bench does not decide anything. The question of orbital, question of ratio doesn't arise at all. The ratio means some point of law decided in the background of the facts are good before the court.
No,
But here-
Mr. Bhattacharya, what I'm on. It is the argument of commission, and it is the argument of it is the argument of the writ petitioners in WPA 845 of 2025 that holding of second written test examination in the year 2024 is not at all illegal, rather it is permissible because of the fact that the observation of the division bench is an obiter dicta, since the same is not germane to the main consideration of the appeal, and the ratio decidendi clearly indicates that there cannot be any difficulty on the part of the commission to hold second examination and proceed thereafter on the basis of that. Now, for the first time, you have come before this court with some papers to substantiate that the order which has been passed by the division bench on 12/9/2023 rejecting the commission's application as well as some third party's application for grant of extension of time on some grounds have been practically affirmed by the Honorable Supreme Court while dismissing the SLP, keeping in mind the grounds taken in the SLP. Now, then what is your stand?
My stand is very clear. My stand is that if any recruitment process, maybe without beyond the little bit beyond the scope of my petition, but since the wholesome argument is there, it's my duty, my lord, to clarify before lordship what should be the basic constitutional position and vis-a-vis the recruitment in the public domain.
Yes.
That's the fundamental thing I would not argue. First of all, my lord, any recruitment process, my lord, has to be in due compliance of Article 14 and 16.
Absolutely.
And if Article 14, 16 were to comply with law, then every eligible candidate as per the qualification required is entitled to be considered to the same standard. On the other day, I was hearing my lord's observation that so far the level playing field is concerned, there is no doubt even in the minds of the court.
Absolutely. Absolutely. That's been
But
done.
if there is no, my lord, disparity in level playing field, then whether I hold one examination, two examination, or three examination becomes not immaterial for consideration.
No. Then Mr. Bhattacharya, then what would be the effect? What would be the effect for not considering the ground as taken by the SLP?
My favor. Well, in favor of my argument. They wanted to get the order of the single bench, division bench upset, showing that since this is the stand of the commission, therefore they cannot, this entire selection should be set at naught. The Supreme Court said after considering, I don't think so, because the commission, if takes another examination, that does not stand in the way. Your
No,
minor
sir.
has to be-
Now, I have understood. What I'm on, ultimately, your clients seek relief that their selection should not be disturbed. I understand it. I understand that.
not only my selection, but if the second is disturbed, I automatically have to get disturbed. I want to submit before Lordship, my Lord, persuade my Lord judicial conscience that when a public authority holds an examination in absence of any allegation of malafide and bias,
But the Supreme Court has practically negated the contention of the holding the second examination.
no, only
Why not?
only
Why not?
I give a example. Look. I go to Supreme Court. Why? I go to Supreme Court that the division bench did not
Extend time.
did not permit reopening of the matter on merit. This reopening was sought for by the commission on XYZ grounds. Reopen it. Commission wanted to reopen and wanted to have the selection afresh.
So the writ petitioner before the Honorable Supreme Court are unsuccessful.
Unsuccessful.
They are with the commission.
No, let me try to explain your lordship. Think of a situation that the single bench has said complete the result, complete the process. Commission comes to division bench. The division bench on merit says no, the direction for completion of process is untouched. But time is extended. Here division bench does not decide anything. The question of without obiter dicta or without the
No. That is the first order.
second also. I'm coming to
First order, grounds not placed, time extended. Second application, while disposing the can, second applications have been filed by the commission as well as by some unsuccessful candidates for extension of time. What are the grounds for extension of time? For allowing the commission to take second test because of some technical error, which has not been considered favorably by the revision bench.
Test means, my lord, to do it afresh, de novo, even cancelling us. They don't say we will take a split second test. But second test, my lord, in the context and background of the commission's prayer was, let us do it afresh, not split. Now, I feel aggrieved. I given just a broad example. I feel aggrieved that the division bench should have opened the issue and directed the commission to do it afresh. Division bench did not do it. I feel like they go to the Supreme Court. Take this point. When the commission says that there was illegalities, why should not the commission be allowed to do it afresh? And Supreme Court, this is not whether simply dismiss the SLP, which we every day face. Supreme Court admits the SLP.
Hmm.
Can you see the language?
Hmm.
Especially petition admitted.
Hmm.
And then Supreme Court says on consideration. This is very important that I am placing. Having heard the learned senior counsel for the petitioners at length, and after carefully perusing the material placed on record, what are the materials? The grounds of the SLP, the pleading in the petition, which having considered, the Supreme Court, we are not inclined to interfere with the impugned order passed by the High Court. Therefore, their prayer was, beloved, in a different manner, to set at naught everything. Now, the High Court ordered that complete the process, beloved, is staring at our face. And how to complete the process? This was none of the business of
No,
the
before
court might
the
decide.
before the division bench, when the division bench passed the order dated 12/9/2023, the commission came with the plea that on account of some technical error, 26,000 and odd candidates have been declared to be qualified in the screening test, and they have been permitted to appear in written test on 29/5/2011, and it is the further stand of the commission that a total number of 74,000 and odd have been left out of the written examination, and they hope to undertake a policy decision in such and such, so grant extension of time.
But may I read once again? Can you
Yes, sir.
sorry,
I
excuse me,
believe clause P is very important.
excuse me, blood,
Clause
my
P.
impertinence, but may I read the order? Order should be read in its entirety. But this is tried submission before this court to say the order cannot be, Milord, read, Milord, bereft of the context.
No difficult, sir. I'm telling you. I'm very frank and honest.
No, that's quite open. I'm happy.
Absolutely. I want to know your specific stand. What whether you are supporting the stand of Mr. Dhar, whether you are supporting the stand of Mr. Mitro, whether you have got any independent stand. I want to know your
But
stand.
I have an independent stand. My independent stand is very clear that the selection process which was initiated by the commission was never under challenge, number one. Number two, selection process since being delayed, parties moved court, Honorable Court said complete the process. Honorable Court did not specify how to complete the process. Then the commission could not complete within the time. But at no point of time the court is deciding anything on merit, with the best of respect. Court grants extension and then a further extension because of certain situation which was beyond the control of anybody. The court says, I'll grant you extension, but complete the process. At that juncture, commission comes up and says that I find these irregularities, not illegalities, irregularities,
Technical errors.
errors for which I need more time.
It has been rejected.
Commission
Such contention has been rejected
division bench.
by the 12/9/2023 order.
Right.
Am I correct, sir?
Absolutely. But what does the division bench say? You complete the process.
Complete the process means
What if
complete the process means, sir. Complete the process means that you are to complete the process on the basis of the written test held on 29/5/2011.
that would be reading something which is not.
Sir, what does it mean, sir? Try to understand what I intend to say.
I explain, I should get it. Now, Milord, I started a process. Process is not complete. Why it is not complete? I find X number sat for exam. It's my duty to give equal opportunity following Article 14(16). I give opportunity to the left out people that you also appear in the exam. If the court finds that these two examinations really creates this level of playing field, the court will interfere. But if the court's judicial conscience find that because of holding of two exams, there has been no disparity, there is no chance of misjudging. I mean, I have argued a matter here, the division bench won. So for the railway examinations are concerned.
Sir, I believe I understand your contention. But try to understand my question, what I am saying. Before the division bench, after the disposal of the appeal, simply by extending the order, extending the time to publish the result, the division bench dispose of the appeal, noting that the grounds of appeal have not been taken in the first order. That is the order. That is the order dated 12/9. No. I'm sorry. 4/2/2020.
Yes.
That is the first order.
Let us read this order. That once again,
That is the
first order.
That is the first order.
May I read it?
No, sir. I will allow you to read, sir. Whole day is your, whole half is yours.
No, it's
So,
my
sir,
pleasure to
now, when the 12/9/2023 order is going to be passed, the Honorable Division Bench came to a finding now Honorable Division Bench came to a finding that
no finding.
no,
I would
rejected. Very good. Rejected the application of the commission as well as the some other third parties by saying that at the time of hearing the instant application, several other issues were raised by the appellants, impinging upon the merit of the order of the single bench as well as the appellate court. It is submitted that subsequently certain illegalities and irregularities have been detected and therefore the court should reopen the entire issue. But till date, no application has been taken out. Only application which is pending. So,
therefore, the court says there is no application.
rejected.
Two
However, time was extended further for 6 months. Am I correct, sir?
Absolutely.
This
Now-
order is under challenge in SLP.
Yes.
Now, kindly come to clause P,
But who are the challengers there? The-
unsuccessful candidates.
Kindly come to clause P. P.
Yes, sir. Kindly read the court portion. Kindly court portion, quote unquote portion.
This is the quotation from the petition filed by the commission.
Yes, that exactly I'm on that.
That is their defense to get the Supreme Court interference to set at not the entire selection. The point is that even if this being the position of the commission, the High Court should not have rejected the prayer for reopening on merit. Not time. Their issue was not time. The issue was that the High Court rejected that we are not going to reopen the merit. This is the complaint. And that's why the Honorable Supreme Court admits the SLP that prima facie there are grounds to be considered, and then goes on merit. After hearing the counsel at length, the counsel, Miller, did not go there to seek extension of time. And what was their prayer in the SLP?
The commission suggested that either they could make the qualified candidate from the screening test,
Yes.
including the ones who already gave this test on 25/9/11, or retake the written examination, or they would want to scrap the entire process altogether and conduct fresh examination. So these matters were under consideration before the Honorable Supreme Court. The Supreme Court rejected the SLP. So what
Why?
does it mean?
That SLP was preferred by whom and why? My lord will kindly consider the SLP is preferred from the order feeling aggrieved. The order of the single bench having been confirmed by the division bench, someone feels aggrieved. Aggrieved on what? Is it for non-extension of time? No. They felt agreed because in spite of commissions having admitted this, the High Court should not have rejected the prayer for reopening on merit. Kindly come to
So
the prayer.
that was not considered favorably by the Supreme Court.
That's my point. If that is not
Then what would be the logical conclusion?
logical conclusion, that if the second examination which has been held, that is not bad, because that was the basic argument and attack before the Supreme Court. But to kindly permit me, maybe at the risk of repetition, the attack before the Supreme Court was, kindly see, kindly come to double A.
ওটা আবার কোথায় আছে?
Kindly come to blood X, W, and X. I think blood the cloud in the mind of the court will immediately be removed. I also place the earlier two grounds. U, because no statement has been made qua the answer scripts of the petitioners as well as other qualified candidates who have already undertaken the entire exercise and their appointments are pending. Because the petitioners have genuine apprehension, ground B, that in terms of the advertisement as issued in the year 2010, the applicants have crossed the threshold age for the said recruitment, and the commission has not made it clear that as to whether the petitioners as well as the persons placed in a similar position would be allowed to appear for the examination or not. They were apprehending that the commission now wants to have a new selection, the age bar might come, they've kindly considered this. Then W, because no explanation has been offered by the commission till date as to what happened to the candidates number so and so who stood qualified. The commission has constantly sought time on 3 occasions to complete and finalize the result. However, at this stage wherein 3 extensions have been granted, now have come up with the new plan to conduct the examination all over again, thus restarting the entire process for which the Honorable Calcutta had not granted them leave. Therefore, this was the apprehension in the mind of the petitioner before the Supreme Court, that the commissioner is going to hold it afresh. Then, because the Honorable High Court had only granted time to the respondent commission, I do not know, excuse me saying so, Milord, this was really a cutthroat defense. The petitioners who have been advised to go to the Supreme Court for SLP, that was a cutthroat defense. They shouldn't have gone, but
Mr. Bhattacharya, kindly tell this court where from you will get this deduction that even after dismissal of the SLP, thereby affirming the division bench second order dated 12/7/2029, the commission got the power to hold the second examination. Where from you will get this deduction?
What the deduction is that the ground of challenge before the SLP was whether the commission can conduct further examination. But that is the ground.
That was not considered.
That was considered and rejected.
Rejected. Even then the commission held the second examination.
Yes, that's my point.
So how it is permissible?
Can we come to that? The SLP says so. SLP says that we have considered everything and we do not find any merit.
Division bench did not permit the commission
Logical.
to hold the second examination.
Division bench did not at all go into that issue. Kindly come
Sir,
to order.
if in the application is it rejected, what does it mean?
Kindly come to order 12/7. I believe not, we have not read the order in its entirety.
Absolutely.
12 September, kindly come to this. Why this prayer? At the time of hearing, kindly listen me. At the time of hearing of the instant application, several other issues are raised by the appellants impinging upon the merit of the order of the single judge. Kindly see what is the attempt to disturb the merit. Why? It is submitted that subsequent certain illegalities and irregularities, nothing related to the second question exam, have been detected, and therefore the court should reopen the entire issue. But till date, no application has been taken out. Therefore, then application in respect of the irregularities or discrepancies, no application is there for that purpose. What is the application before the division bench? Extension of time. Therefore, if nothing is before the division bench will not, or no court will in fact decide or go into that. What the Supreme Division Bench says, there is no application. I am not considering that. I am only concerned with extension of time. Otherwise, this part of the order, my lord, goes absolutely without any justification. Division bench was very much conscious. That's why they say, since there is no application, once again, my lord, maybe repeating, therefore this was prayer. But till date, no application has been taken out, and the only application which is pending before us is the extension of time to complete the process. Therefore, the division bench had no occasion even to consider that aspect. You are saying so, but what is the application? And my lord, a statutory body, my lord, without any application or affidavit, statement from the bar, no court will accept that. Therefore, this was never an issue before the division bench. Whether the division bench was called upon to decide whether the second examination can be held or not. And that's why, my lord, I am, with deepest of respect, my lord, I say, no question of any obiter, no question of any ratio.
No, there are then in the subsequent order it has been passed. It has been rejected.
12 September is last order, I believe.
No. After that, there is an order.
Let me not check it. Lord. Without checking, my lord, I should not bring a submission. Yes, my lord, the 13th of June, 2024.
Yes.
Yeah, let me also place this order.
13th June order has not been made part of the composite evidence, Mr. Dor.
Yes,
What is that, sir?
I have placed it.
No, you have placed, but I have not
Yes,
flagged
yes,
it.
yes. It is,
Kindly
I
tell
have
me the
read
page.
in the writ petition at page 74.
That is at page number 70.
Yes,
In your composite,
composite. Let me check it. Composite আছে দেখো। Kamal, it's there in the writ petition only, not in the composite.
that I am saying. Now, Mr. Bhattacharya, come to order date 13/6/2024.
That again, suppose,
Internal page number 6.
no, let us read the entirety.
Very good.
That what is the background? The
So,
initial-
let us comprehend in this fashion that while passing the order dated 12/9/2023, I believe it is your contention that the Honorable Division Bench had no occasion to consider the stand of the Commission for holding the second examination. And the Honorable Supreme Court, while disposing the SLP, has also not touched on that.
Yes,
That is your stand.
that's my point. Very good. Now kindly come to a 13th June order.
Let me note, sir. Let me take. Yes, Mr. Bhattacharya.
Now, kindly let me not paste 13 June, but I shall paste from the beginning, which reflects the mind of the court. The belligerent order 13th of June.
এটা ভাগ দিচ্ছি তো।
13th of June.
Yes.
The belligerent litigants have taken out successive applications seeking extension of time to implement the directions passed by the single bench while disposing of the writ petition on one pretext or the another. That gives the mind of the court. The impression gathered, I don't have to read, the court has given, impression gathered from the conduct of the applicant is evident that an attempt is sought to be made to thwart the directions and orders passed by the single bench at the time of the disposal writ petition. Writ petition was taken out by the respondent in instant appeal seeking several directions, including that after participating in the written examination, the results have not been published and therefore his fate is still in large. A plea was taken by the applicant in the said petition that the result of the written examination of first level selection test is yet to be published as the instructions sought by the Commission from the Minority Affairs had not been received yet. The single bench has endeavored to find out any rules concerning the Madrasa Commission for such instruction. Being evitable, it was highlighted that Rule 17 does not indicate that where the written test has been held, any further instruction to complete the process from the department is required. However, there appears to be a dissent on the date of the written examination, which have been vividly and lucidly indicated by the single bench, and directed the appellant to evaluate the answer script respondent 1, and after evaluation, answer script shall prepare the panel in terms of Rule 18 of the recruitment rules. It is observed that in the event the respondent is found eligible, he should be issued invitation letter so and so. The Reed Court was conscious of the dormant and the slow pace of movement. Kindly see what has been paining the court, as is paining us also. Reed Court was conscious of the dormant and the slow pace of movement in the government department and expressed the view that in the event the exercise could not be completed within 14 days, that can be done within further 7 days. The said order was assailed by the Commission by an intra-court appeal, which came to be disposed of on 4th February by modifying the impugned order to the extent that period of completion of the entire exercise appears to be insufficient, and therefore the entire exercise is to be completed within 6 months from the date of the said order.
That is the first order.
Yes.
That is the first order while disposing the appeal.
Despite the modification of the order extend the time, which in our opinion appears to be reasonable, an application was taken out seeking extension of time. Amidst pendency of the said application, several applications for impleadment as party in a disposed of proceeding were filed by the applicants, therein which were dismissed on so and so. Simultaneously, the court also extended the time for a period of 6 months from the date in anticipation that the authorities cannot act contrary to the directions passed by the court. Despite time having extended, the instant application is taken out. Now, I'm sure had it been, this court would have been more stronger in its language. Repeatedly, you are coming for extension of time. What are you doing? A plea has been taken on the declaration of the parliamentary election. I do not waste time. Interestingly, paragraph 9. A plea is sought to be taken before us that in the affidavit in opposition as well as the instant appeal relating to conducting the written test after scrutinizing the applications filed by the aspirants in the regard the letter dated so and so is sought to be relied upon, wherein the examination center for conducting the first SLT was to be conducted. A litigant is not permitted to prevaricate its stand at the different stages of the proceedings. If the plea was taken in the writ petition and the court ultimately disposed of the proceedings even without recording any finding thereupon, it is deemed that the said plea has not been accepted by the court and deemed to have been rejected. Even before the appellate court, it does not appear that any such plea was taken or argued at the time of hearing, and the order of the single bench was affirmed with the modification to the effect that the time limit for completion of the entire exercise is extended for a period of 6 months. Interestingly, the first application for extension was disposed of extending the time for a further period of 6 months, which necessarily implies, underline this, which necessarily implies that such plea which is sought to be projected for the first time in the instant application was not pressed. A plea of res judicata also applies in the instant case. The plea which ought to have been taken or was taken and the decision had been taken finally, it would be deemed that the said issue has been decided finally and cannot be reopened at the subsequent stage. We are conscious that the plea of res judicata not only applies between two proceedings but has equal applicability at different stages of the same proceeding. The principles of res judicata is based on a public policy, even though I do not waste time. Then kindly come to paragraph 12. The cascading effect of permitting the litigant to take a different stand at different stages is that the litigation would remain open, and it would augment and encourage litigations to travel in the docket of the court, and there will not be any certainty in this right claim to parties. We are unable to accept the contention of the applicant that a plea was taken. Therefore, all the questionable of plea taken or not. Such plea having been taken in the
No, sir. Read that paragraph. It's very, right, sir.
we are unable. We are
Paragraph
unable to
13.
accept.
Paragraph 13, sir.
Yeah, I'm reading. We are unable to accept the contention of the applicant that a plea was taken, that there has been a large discrepancy in the scrutiny procedures. Therefore, authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in written examination. This plea was for the purpose of extension of time. That the division means negative. Such plea having taken in the writ petition as well as in the instant appeal, but was not found favor, cannot be re-agitated in an application seeking extension of
Such
time.
plea having taken in the writ petition as well as in the instant appeal.
For what
That plea was taken.
For what purpose? Kindly read this, paragraph 14. Such plea having taken in the writ petition as well as the instant appeal, but was not found favor, cannot be re-agitated in an application seeking extension of time to complete the process. Therefore, court was, well, that's why it says, read the first paragraph. Court was only concerned that you were repeatedly seeking extension.
No, Mr. Bhattacharya, it has got some depth, sir. So far my understanding goes, such plea having taken in the writ petition as well as in the instant appeal. What plea? The technical error.
Then for what
What
purpose?
was not found in favor cannot be re-agitated in an application
Yes.
seeking extension of time.
Yes,
Now
because
let us visualize the situation. Such plea having been taken in the writ petition as well as in instant writ petition appeal was not found. That means it was while appeal was taken up for hearing for the first time, and the grounds have been abandoned. Grounds have been abandoned. Now this plea cannot be taken. That is the technical error. Plea cannot be taken as a, because the Supreme Court, the division bench held, it is opposite to the policy of principle of res judicata.
May I just point out that this would be apparently without inaccurate recording of facts. Kindly read the 12th September order. 12th September order says for the first time, the plea of irregularities are taken for purpose of extension, but since there is no application, we are not considering.
Very good.
Therefore, this recording, that's why I say read the entire. This recording was an inadvertent record by the honorable judge.
It may be.
Then the 14 is also important. But all this plea cannot be taken for extension of time to complete the process. Then paragraph 15. Since it relates to a recruitment process which is already delayed for nearly a decade, authority must be sensitized and a sense of responsibility required to be percolated in them that any dormant and lethargic attitude has a ramification over the rights of the eligible candidate. Again, my lord, the court is concerned only with the practice of delay. We do not find any sufficient reason which impedes the progress to be made for due implementation of the single judge as modified by the division bench and the further plea of moral code of conduct having imposed my lord, this lordship has considered, can forget it. Then we will proceed to reject this aid application by considering the plight of the candidates. What application? Extension of time. In the written examination, and because the careless conduct of authorities, their fate is still in large, or in other words, uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. Therefore, ultimately,
No, sir. Read, sir.
yes, we are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by a single bench as well as division bench. And the direction was plain and simple that after conducting the written examination, the answer script are to be evaluated. And the panel is required to be prepared indicating the successful candidates.
What you let us take a pause, sir.
Yes, let
Then
us.
what would be your contention? I memorized the contention of Mr. Dhar and Mr. Mitro, as well as the Mr. Mojumdar, Mr. Bhattacharya, and Mr. Sami Ahmed. What would be your contention over this? We two successful candidates. What would be your contention?
May I- Now, kindly
I want to know.
what is the issue before the court then? Kindly visualize the application for extension of time.
And what is the basis of application, sir?
That in that application, my lord,
No, what is the basis of the application?
basis of application was parliamentary election, COVID, all this.
No. Basis of the application was subsequent detection of the alleged illegality or irregularity. That is there.
Kindly come to the
That
application.
is. As otherwise,
Kindly
this
come.
observation ought not to have been made by the Honorable Division Bench.
Are below of the cup observation. I will show. Kindly come to page.
This is the plea of the commission while passing the order of the
Now, kindly come.
12/9/2023,
Right.
as well as the plea of the commission on 13/6/2024.
This is the understanding.
Then why the Honorable Supreme Court, Honorable Division Bench has made this observation?
May I just clarify? Kindly give me 10 minutes. First of all, 12th September, say we do not consider this because there is no application. This is very clear. The plea of irregularities.
Sir, that I understand, that I fail to understand why it has been written, because you have shown the quote unquote portion of your the SLP petition,
Yes.
because it is the quote unquote portion of the SLP. I believe it has been taken from the application which was under consideration on 12/9/2023. While undertaking the process of evaluation, several technical errors which are serious in nature had occurred. So this plea was there. Now, from this finding, the plea is also there before the division bench, that take on account of our technical mistake or error, several candidates have been left out.
But don't.
Even then, the Honorable Division Bench did not allow that application, holding that we are unable to comprehend the stand of the commission.
But this is the position. I just not trying to clear the cloud. First of all, the question of irregularities was first raised before the court on 12th September 23.
Absolutely.
The court said that there is no application, therefore I am not considering. Therefore, 12th September does not.
I don't know what is that, but because no, sir, I understand.
Therefore, 12th September.
Sir, just a minute. I don't know what happened there, but just now you have said that might be division bench has made some mistake,
No.
because you have given me a copy of the SLP petition.
That was not placed.
Where quoting and unquoting portion is there, which says that at that material time, that prior to that while passing the order date 12/9/2023, this plea was taken by the commission. I don't know why division bench has held that.
Again, kindly come to order of 12th September. Once again come. 12th September.
I understand, sir.
Categorically says that this plea is taken, but there is no application.
There's no application.
Therefore, that
I'm with you, sir.
now
Now you have said some unsuccessful
Sir, let me-
candidates,
let me clarify.
no, sir. My clarification is required for giving
Yeah, Judge,
justice.
yes, I'm
So for you have given me the copy of the SLP where some unsuccessful candidates have quoted a portions of the petition of the commission where the technical error, alleged technical error has been mentioned.
may I just, this is a SLP from 12th September order,
I understand.
right? So in 12th September order SLP, they take this plea that this was the commission stand. Commission stated so.
Commission stand must not be in air, must be in black and white.
The
That means that that was there in the before the division bench.
division bench said.
I don't know why it has been observed by the honorable division bench.
Says categorically, well, today probably this cannot be reopened, that there is no application seeking time or seeking further direction so far these irregularities are concerned. Only application, they might have said so, but application is seeking time. Kindly read once again.
This was also an application for seeking time.
Which one? Yeah,
This one.
I'm coming to that. There were 12 September, my lord, the division bench was considering only an application for extension of time.
Mr. Bhattacharya, when the honorable division bench was passing an order dated 12/9/2023 and when the division bench was passing the order dated 13/6/2024, on all these two occasions, the prayer before the honorable division bench was for extension of time. But we want to say that sitting while disposing all these writ petition, this court will close its eyes to the contents of those applications, on what basis or on what grounds these applications seeking extension of time has been done. That I intend to do. I will go to the prayer portion
I-
or I will go to the contents of the
But I will-
application which is available in the order itself.
Now, kindly allow me to, my lord, help your lordship. First of all, my lord, even if the materials are there, assuming the words against me, but the court said that there is no prayer that he should be permitted to do X, Y, Z for this
That I
irregularity.
understand. Absolutely.
Therefore,
No prayer was there.
that's why the SLP was taken. SLP was taken that this statement having been there, the division bench should not have
Extend the time.
rejected the, should not have refused the prayer for reopening on merit. Division bench says 12th September that they want to reopen the merit. We are not permitted. We are simply granting extension of time. Looking at the amendment made therein, that if there is no prayer seeking specifically that on this basis, you permit me to hold the examination. There was no finding, not even any discussion. That prompted some of the candidates to go up to the Supreme Court. That in spite of such pleading, assuming the pleading we have quoted, how come the court refused to reopen the issue on merit? The Supreme Court says after having admitted the SLP and after hearing the counsel at length, we do not find any merit on this. Because the issue of irregularity and other things were never decided by the division bench.
Very good.
That's the reason. Now with a subsequent application, which is troubling my lord and also troubling me to some extent, but I am sure I can explain. Kindly come to order of 14.6 and the application. What was the application? That is on page
152.
152 of the bunch.
Composite.
Composite.
Nevertheless, here also, my lord will be pleased to find, yes, there is a statement. Statement was there before the court even on 12th of September, from which the SLP was taken out.
Total examination. Total exam.
Now, my lord, kindly
Page
come-
152.
Page 152 is the application. Kindly take the trouble to turn to page 156.
Hmm.
The appellant state that on 12th of September 2023,
Hmm.
during the pendency of such application,
Hmm.
kindly underline this,
Already underlined.
already taken a policy decision to conduct fresh written examination of a total of such and such candidates which were left out, along with 26 candidates who had already appeared in written examination of Group D held on 29th May 2011. Therefore, they wanted to have a fresh examination. This was there. Then, paragraph 4, appellant state that upon passing of the order dated 12th September, the following steps have been taken to comply with the orders. Now, I am not again troubling my lord to that. Then the prayer was, in the above circumstance, it is prayed. In the above circumstance, it is prayed. Allow this application and direct modification and or extension of time as prescribed in the order dated 12th September 2023. Giving these backgrounds, they shall let time be extended.
So modification application also goes.
Everything goes. Now, kindly, the modification will not issue to the time. Modification or
No, sir, we have to consider it as a whole.
no, yes, in the context. Now, in the modification, my lord, they couldn't have prayed in view of the Supreme Court judgment. That was not all placed. There was Supreme Court order, my lord, prevails, and my lord, staring at our face. Now,
The appellant state. Come to paragraph 3 once.
yes,
Page number 1, the appellant means the commission. That on 12th September 2000, during the pendency of such as they had already taken a policy decision to conduct fresh written examination of a total of such and such, that is candidates which were left out, along with such we have already in 2011. Now, the appellant, upon passing of the order, following state, the list of candidates eligible for appearing has been finalized. Letters have been
therefore, my lord,
dispatched to
the issue of holding examination remains untouched, and it is also reported to the court that we have taken this decision.
এবারে পরীক্ষা করলো ডিস্ট্রিক্ট ম্যাজিস্ট্রেট রিগালিং অ্যাভেলেবিলিটি অফ এক্সামিনেশন সেন্টার অনলাइन transfer process lack of staff due to the numerous recruitment process. So by filing this scan 20 of 2024, the commission has placed all the cards before the
All the cards.
before the division bench for and place all the matters that they are now prepared to take fresh examination in respect of 74,000 examination, which is why they have prayed for modification and extension of time. So the writ petition, the can 20 is dismissed.
Dismissed. No
Then-
time is extended.
No modification is also given.
What modification? After Supreme Court order, even the High Court doesn't have jurisdiction to go into modification. Then your lordship, have to say that the Supreme Court order doesn't have any existence. That will be a disastrous impact. On the same issue, the matter went up to the Supreme Court. Supreme Court having admitted SLP, I am repeating this issue.
Then how the commission, if the application for modification and obligor
What
extension was,
modification?
that I don't know. What is there, that is there.
Right, but the court has to
What is
decide
there, that is there. I
Right.
cannot explain, sir.
the modification of the order. What was the order of 12th September? The modification cannot be
That you people will explain.
no, you have to decide. So what
Obviously, I have to decide. Can
What-
20 is an application for modification and or extension of time. Can 20 dismissed. Application for modification and extension dismissed.
Right. But
Then how the commission can hold the second witness? That I intend.
I simply answer, Lordship, but the modification of 12th September order. But forget about extension.
And forget about the order of the previous order and order of the Supreme Court also.
So the Supreme Court I cannot forget.
Very good. Don't forget.
The commission and the parties, they were bound to place the order of the Supreme Court. They did not do it. That would not make the order valid, number one.
Very good.
The Superior Court's order under Article 144.
So if the Honorable Supreme Court's order is viewed from a different angle, It says that the previous order dated 12/9/2023 stood affirmed. Very good, sir. Very good, sir. I for the sake of argument, I accept your contention. Now, so far can 20 is concerned. You have
Can
placed,
again without
it is an application for,
reject.
no sir, application for modification and or extension. What are the grounds that have already decided, stated? That has been rejected.
Reject.
My
What
simple
remains?
question is that after rejection, how the commission can hold the second exam?
Without the holding policy decision was never considered by the division bench or any bench. Even the 14.6 doesn't say we go into merit and we find no. This cursor is saying
Then how the modification has been modified according to you?
nothing to
How the
modify.
modification application has
But
been?
it's absolutely the prayer which has no foundation. My lord, we have to decide on the basis of law, not on the basis of the prayer made. We are seeking modification of what? The order is extension for 3 months. The order doesn't say anything else. Kindly see the order of 12th September. But if I today approach your lordship seeking modification, I have to demonstrate.
Mr. Bhattacharya, I am telling you, what is the implication that will be reflected in my judgment?
Of course, sir.
Sir, when the first order in the appeal was passed, the commission was not aware of their alleged technical difficulty. First order, which is why they abandoned the grounds of appeal. Am I correct, sir? No, I need not be correct. You don't agree with me. So far, the second order is concerned, for the first time, the commission had disclosed their alleged irregularity or illegality or technical error in the version of Mr. Dhar, which reveals from the SLP petition. I accept your contention that the Honorable Division Bench, while disposing the order dated, while passing the order date 12/9/2023, did not consider the application for that application, however, extended time. This much. For the sake of argument, I accepted your contention. Now, CAN 20 of 2024 is a composite application or an application with an alternative prayer for modification and oblique extension of time, extension of the order date 12th September 2023.
Right?
Why?
Yeah.
Why?
No.
Because of the fact
Application.
that on account of such and such persons have been left out.
Now, I have understood your lordship. That if I come before your lordship today with a prayer without
Then how the commission can take the second examination?
that I will satisfy, it can be even under the rules, but to clarify these things. Now, today, my lord, forget about this matter. I approach your lordship seeking an application, kindly modify this order. My lord will first ask me, what are the modifications you are seeking? What is the pleading? Therefore, the prayers cannot be, my lord, considered independently bed after pleading.
Absolutely.
Yes, now kindly
I'm
come
with
to the
you.
application. Now kindly, it's my duty, my lord, to point out to your lordship. But this is, my lord, kindly come to my application. The paragraph 3 says, the appellant state that on 12th September 2023, during the pendency of such application, they had already taken a policy decision to conduct fresh written examination for total 1 lakh candidates. Therefore, 1 lakh candidates, fresh selection, that was really their policy decision. That's why, below, that SLP was taken by them also. And that is to 74,000, and already who have all passed 26,000. Sum total 1,01,000. If this is the pleading which is argued that this modification was sought for, it was refused. That's my favor. That's in my favor. And the commission, my lord, could not have held the entire examination. The commission has held, my lord, split examination. Those who have qualified. Those who were not in a position to appear, Article 40 comes into operation along 16, give them opportunity. Now, my lord, the question would come if there is again, my lord, I repeat, now there is, my lord, lack of level playing field. These two examinations is so disparity, then question of normalization would have come. But here, my lord, there is no allegation of any, my lord, lack of level playing field, number one. And number two, there is no allegation of, my lord, bias or malafide. At least I don't find. If I find, I will correct myself. In this background, now Lordship kindly takes up the statutory rules. I will show rules permit.
এখানে দেখি দাও রুলসটা দেখি বাবা বললেন বাবু ও দেখো রুলসটা দেখি রুলসটা আছে তো ওখানে। আমার দিন ওখানেই থাকার কথা যাবে কোথায়
But I'm very frank, Lord, after a long time, I'm enjoying arguing a constitutional issues before Lordship. Not constitutional, I mean administrative issues. But kindly takes up the rules. Yes, that will also help me.
আমাদের হেল্প
Yes.
Now, kindly Miller takes up these rules for recruitment.
Yes.
Kindly turn to chapter 3.
Yes.
Number the method of selection.
Yes.
The selection of persons to the different posts mentioned in column 2 of schedule 1 shall be made through commission. No problem. Manner of selection, this is important.
Yes.
Selection to any post shall be made on the basis of results that can be underlined state, oblique region, oblique area. That itself indicates below the different examinations can be held. Now, this I will place to show that the rule makers had in mind that there may be different examinations and that will not be bad. Here, Milord, we had commission had rather the statewide selection, and the opportunity was given to all, maybe holding Milord two separate examination. Now again, I will not take the cue from Milo's observation. The court has found, yes, there are two examinations, but there was no lack of level playing field. No one can complain that because of this examination I have suffered with the earlier one. If the rule permits holding separate selection procedure, but if I, because of the volume of candidates, split the exam, would it be absolutely irrationally illegal? Would that violate Article 14 and 16? I will just invite Milo's kind attention to Article 16. This is very important in case of public employment. But this is the employment below where state funds.
Mr. Bhattacharya, give me a second. কনস্টিটিউশনটা কোথায়?
Probably this has been gone through by this court 1,000 times, but still, reading at a increment of time throws new light.
Absolutely.
That I had, as a young lawyer, seen Mr. Ashok Sen was arguing before Justice Desai and showing civil procedure code. We are then observing then Justice Desai, Mr. Sen, we have read it 1,000 times. Still, we find there's something more in it.
That always happens. That always happens.
Absolutely.
Now, equality before law. State shall not deny to any person equality before the law or the equal protections of the law. Because state cannot deny. Even by mistake, state cannot say that XYZ would be denied the opportunity. And then kindly turn to Article 16. There shall be equality of opportunity for all citizens in the matter relating to employment or appointment to any office under the state. Now, if this is the basic constitutional principle on which all the recruitments, particularly funded by the state, has to follow, here rules provide that there may be selection on the basis of results of the state-wise, region-wise, or area-wise. Therefore, the statute makers had in contemplation there might be different examinations. Subject to, that's my judicial understanding of law, that these examinations should not be in such a manner that one group puts into difficulty or disadvantages with the others.
So has it been done, sir?
It has been done, my lord, to split examination, but
State-wise, region-wise, or area-wise? Has it been done in this case?
Lord, I am just no. I cite this to show that the statute makers had there in mind that there might be situations where different
Absolutely.
examination may be. But in our case, no, this was state level. What is the complaint? That in state level, you had splitted the examination. 2000 and then rest. Now, this splitting, can it be demonstrated, or was it demonstrated because of splitting one group gets favored than the other? If your lordship finds to that, I will out. But if the judicial conscience comes to the conclusion that there might be split examination, giving opportunity to all, following the principles of Indian Constitution, Article 14-16, but this split does not put one group in an advantageous position than the other. Because ultimate panel was
Sir,
prepared by
if my recollection does not betray me, 2 points were taken on behalf of the petitioners. One is level playing field. To that, I have expressed my mind. Another is process of normalization. Am I correct? Process of normalization. So where is that process of
the
normalization?
normalization would arise only when it appears, my lord, the two examinations to different standard. My lord has expressed mind, judicial mind, that level playing field is there. What does it mean?
Same standard of question papers.
That's all.
That's all. But
Now, why, my lord?
sir, what I'm on, Mr. Bhattacharya, that apart from standard of normalization, where are the authorities of the commission to hold the self-same examination for the same categories of candidates, or the candidates having the same footing on two different occasions?
I just
That you are saying, I am accepting that. Rule 8 says you can take it state-wise, you can take it regional-wise,
Therefore,
you can take area level, but it has not been done.
now, what again, Milord, I am unable to communicate. Milord, I cite this to show the statute makers had in their mind that there may be different examinations. But that was
There may be different examination,
different level.
but categories have been mentioned.
Right, so I say,
State-wise, region-wise, area level. Right?
right, so my lord will not kindly go by literal interpretation. You have to go by the constructive interpretation or contextual interpretation. The interpretation both becomes textual and contextual. Here, the context is that there is huge number of candidates. Therefore, the statute makers thought it may be state level, area level, district level. What I submit, my lord, yes, this was not on the basis of zonalization. but examination was held at the state level, but in 2 occasions. The holding of examination 2 occasions is not, Milord, either anti-reasonability or that goes beyond the perception of holding public examination. That's the first point. Second point, the normalization would arise only when, Milord, there are different set of examiners. That in a similar case, railway judgment edition I shall say, the normalization would arise where, Milord, the arose that at the different level, different examiners were there. Then the Supreme Court said that you better normalize, follow the process of normalization, because different examiners would mean different understanding.
Very good. Then
But here-
your contention is, Mr. Bhattacharya, since rule 8 permits the commission to hold examination state-wise, region-wise, and area level-wise, if we visualize the contextual position of this case, there cannot be illegality on the part of the commission to hold the self-same examination twice or thrice. That is your contention.
Yes. Provided, Milord, the level playing field is not attractive. अरे तो रेलवे ची मामला तो विक्रम दे जवान होता है দেখি সেখান থেকে দাও আমি কি লিখেছিলাম দে 2013 অ্যাভারেজ
2013
কত
Yes, Mr. Bhattacharya.
And, Milord, here, if, Milord, some candidates were left out because of, Milord, the laches, incapacity, indolent behavior of, Milord, recruitment authority, that cannot be appreciated.
Yes.
Now, Milord, kindly turn to chapter 6. Arrangement of written test. Hey, Kalpun Bachi. Milord, Rule 15, arrangement of written test.
Yes.
The Commission shall arrange for written test under its direct supervision and control. The Commission shall determine the scheme and syllabus of the written test, prepare question papers and distribute the same to the examination venue through the custodian appointed by the Commission. Now, but there is no allegation that the Commission did not do so. Commission held the written test, Commission has fixed up the syllabus, and the Commission has gone the assessment of the written test through its own supervision. Then 16, holding and conduct of written test. The Commission shall hold written test of all the eligible candidates. This is a statutory mandate. Failure on the part of the Commission to do so, Milord, cannot deprive an applicant from being properly considered. Therefore, the duty of the Commission is to hold the test for all eligible candidates. Now, here the Commission, Milord, had held it maybe in split manner. The Commission shall decide the procedure and manner of conducting the state, region, and area level selection test and prepare detailed instruction in this regard in accordance with the provisions of the Act and the rule made thereunder. Commission, my lord, had followed this or not, that would be one of the consideration. To my understanding, my lord, this has been strictly followed. Then 18. No, 17 also important, because why this normalization would not at all arise. Normalization arose because of human error. Here there is no question human intervention. Evaluation of answer script. The Commission shall get the answer scripts of the written examination evaluated by examiner a computer-based technique and prepare evaluation sheet, medium, post subject, so and so. But I believe here that the Commission has done it on the basis of the computer test. Therefore, there was no scope for any human intervention which could make a little variance, which ultimately led to normalization. I shall rely on that. Then preparation of list of candidates. After the evaluation of answer sheets of the written examination, the Commission shall prepare medium so and so, who shall qualify for the personality test on the basis of the marks obtained in the written test and evaluation of academic and professional qualification. Therefore, personality test does not depend exclusively on written examination, but also depends upon their academic qualification. Now, is there in such allegation? I am not yet able to find that the Commission had failed to do this. Commission had failed when Commission did not, but was not able to hold the examination of all eligible candidates. I emphasize. And having held the examination of all eligible candidates, if someone feels aggrieved, he has to definitely specify. Categorically say, but because of X reason, I am at disadvantageous position. And personality test doesn't depend only on the written test, but it also depends on the academic standing.
Yes, Mr. Bhattacharya.
Then we'll kindly come to chapter 8, preparation of panel.
Yes.
22 and 23, publication of panel. Now, the question comes, the REIT code directs you complete the process within X time. The REIT code did not permit that you jump the line and complete the process. If I have to complete the process, I have to take the examination of all. That is statutory mandate. Therefore, the determination of the single judge and division bench enforces me to expedite and complete the process. But I have placed the statutory requirement of completion of process. That has been done. There's nothing complained that this process has been followed. On the contrary, someone had complained and gone to Supreme Court that if the entire examination is held, then I will be affected. Therefore, the 26,000 whose examination have been held is held. hold examination for the rest of it. That is reasonable, not irrational, not unreasonable. Unless it is irrational, my lord, it would not hit Article 14. On the contrary, my lord, if this followed, the Article 14 is complied with. It with Article 16. But I would not add anything more than the, my lord, the requirement, the statutory provisions and which the Commission is bound to. Now kindly come to, my lord, the issue of normalization. I will straightway take, I am sure you are aware of this judgment, the celestial appointment of the higher judiciary. This is 3 judges bench judgment, 2013-11 Supreme Court cases, page 87.
2013,
11 Supreme Court cases, page 87.
2013, 11 FCC, page 87. Relevant paragraph, sir?
Yes, well, I shall place him about with a caveat because this relates to appointment of judges.
Very good.
Well, the standard is much higher than that of, the
Not much. Much.
yes, but
Much is not enough. Paragraph 39, 40,
Yes.
41.
kindly,
এটা 146 নয় ইনারা অ্যাপিয়ার করছেন হচ্ছে এরে
এই আমাদের
সরি
WP নাম্বারটা বল।
WPA নাম্বার 1436 ইয়েস 146 ওনার আগের জাজমেন্ট গুলো কি হলো না আগে যেগুলো দিয়েছে না ঠিক আছে চলো ইটস অলরাইট এইখানের কাজ
nevertheless,
sir.
I always prefer to cite a judgment showing the backgrounds on which this blood issue was decided.
Absolutely, that
Otherwise,
is necessary.
they shouldn't come. Paragraph 2 blood, this gives the background of the issue before the Supreme Court. In writ petition number such and such, the challenge is to the selection made by the High Court of Madhya Pradesh in the cadre of Madhya Pradesh Higher Judicial Service to the post of entry-level district judge in the selection process for the year 2006-7, in which the third respondent alone came
But
to
I'm
be
seeking
selected.
little leave.
Palachcho. The petitioners and the respondent 4 to 8 were all unsuccessful candidates who participated in the said selection. The lead petition number such and such also by one of the candidates who participated in the selection and has come forward with similar relief as in lead petition number such and such have been preferred by 2 candidates who were also not successful. Now, this is the background. In this background, number of points were raised. Let kindly come to 11th paragraph. Now, I shall place paragraph 37.
Yes.
37 Malak, point 5. The others are not, I am reading. The expression evaluation would therefore take into its fold the minimum marks to be scored, the manner in which the evaluation is to be made, and in the event of any requirement to equalize the merits of the candidate in the written examination and follow any appropriate procedure in consonance with law in order to ultimately arrive at a fair process by which the candidate can be called for interview based on the evaluation of the marks in the written examination. Well, kindly sees the background. In a situation like this, where nearly 3,000 candidates appeared for the written examination, and the answer papers were evaluated by several district judges, it cannot be held that there was every scope for variation in this assessment of the answers and the award of marks valued by different valuers. The High Court, in exercise of its statutory power, adopted a fair procedure to normalize the marks of the candidates in order to assess their respective merits. Therefore, normalization comes when it is evaluated by several district judges. Now, the understanding varies. And in this background, Lord, the court says that normalization requires when, at what point of time. Kindly come to paragraph 52. While noting the purpose for normalization, now, the
Yes.
purpose of normalization was, since that was going to be evaluated by different district judges. While noting the purpose for normalization as per the second resolution selection committee, the above referred to stand the first respondent can be noted. We have to, however, state that in the said statement, what has been stated about the first resolution, namely the determination of marks, 35% for reserved category, 40% for general category, has not been correctly stated on behalf of the High Court. We have to clarify the said position in order to efface any misunderstanding about the procedure followed by the selection committee. In other words, since the selection process was entrusted with the selection committee and the said process was carried out by the selection committee by passing an appropriate resolution, and based on such resolution, the required statements were also prepared at the base of the selection committee. We are of the view that it will be appropriate to state what exactly was the procedure actually followed by the High Court. Based on the materials placed before us, certain inconsistencies which are found in the counter affidavit filed on behalf of the High Court as compared to the annexures filed have to be stated. Therefore, in the above extracted part of the counter affidavit as found in para 10 as compared to the resolution of selection committee, we find that as per the selection committee's resolution, the candidates who had secured 35% in reserved category and 40 in general category in each of the papers, based on evaluation made by the district judge, was determined as the criteria to qualify for vibrancy. Put it more precisely, a candidate, in order to become eligible to participate in the vibrancy, should have secured, insofar reserved candidate is concerned, 35%, and insofar as general category is concerned, 40% separately in the first paper and in the second paper, and not in any one of the papers as sought to be explained in the opening sentence of the counter affidavit. Now, but these are the discrepancies which the court found. Then court comes to the conclusion why the normalization is necessary. I am not troubling my lord with that. Here the court says, in paragraph 75, applying the principles laid down by this court, we find that the procedure adopted by the first respondent High Court was well in order, and the same does not call for interference. Having regard to our above conclusion, we do not find any merit in the petition. The same was supplemented by the Honorable Justice Kabir, who was then the Chief Justice. And another judgment. This is not 2001, Volume 4, SCC 289.
2000?
2001, Volume 4.
Page number, sir?
Volume 4, Milord, page 89. 289, sorry.
289.
নিয়ে চলে গেছি আমি ট্যাপটি
দিয়েছিলাম তোকে।
Yes.
No, it's a very short judgment. It's on the point which is settled. The appellants who have not impaneled have no right to challenge. Many judgments have been cited in this paper.
So, Mr. Bhattacharya, so from the judgment of 2013 SCC, we find that the Honorable Supreme Court, while considering the recruitment process of Madhya Pradesh High Court, has found that the recruitment committee of that High Court has made the process of normalization of the marks obtained by the unreserved category candidates and the marks obtained by the reserved category of candidates, both in the written test and in the viva examination, supported by resolutions made by the said committee.
Yes. But,
That question I have asked Mr. Dor,
look, I
that where is the resolution of the committee at that material time, that if necessary the commission will hold the written examination or the same written examination in phases.
It was not necessary. Here it was necessary because of rules. The 2013, my lord, the High Court rules say. That's why the Supreme Court said that in terms of the High Court rules, they have taken a resolution. And but as I said, with the caveat, this was with regard to the appointment of district judges
Very good.
with a very superior level and strict observance. Here, my lord, I said that the rules requires that everybody has to be examined.
That naturally.
Yes. Therefore,
Otherwise, the rule Article 16 will be violated.
here they have whatever the reasons they had did not my lord, initially hold the examination for all. Now they have to get the examination of all. But the question would arise, as I'm repeatedly asking, that this is without the computer-based, therefore no question of human intervention, normalization.
Very good, sir. I understand. Normalization done.
That will kindly come to the 2003, Volume 9, Supreme Court cases, page 401.
2003, Volume 9, SCC. ওটা কোথায় কল্যাণ কোথায় গেলেন? দিন পেজ নাম্বার
401.
401.
There were, these are some similarity. I just place it here. These appeals are directed against the common judgment and order so and so. Controversy relates to selection / non-selection of candidates to the post of Assistant District Transport Officer. The Punjab Subordinate Selection Board advertised 12 posts. Out of them, 7 posts were for the general category and 4 for the SC/ST, and 1 was reserved for ex-servicemen. A written test was conducted on 24th March 1996, the result of which was declared on 1st April 1998, declaring 78% successful. Out of these 78%, 61 belong to the general category, 15 belong to SC/ST, and 2 belong to the ex-servicemen. Later on 22nd April 1998, 40 more candidates, kindly note this, were declared successful by lowering the standard. Out of these 40 candidates, 21 belong to general category, 13 to SC/ST, and 6 to the ex-servicemen. Criteria for selection were framed on so and so. Final result was declared on so and so, and the appointments were made on so and so. Out of the candidates selected and appointed, 6 were from the general category, 3 were from SC/ST, 1 from ex-servicemen. Out of the 78 candidates whose result was declared on 1st April 1998, 4 candidates belonging to the general category were selected. However, out of the 40 candidates whose result was declared later, 2 candidates belonging to the general category were selected. The appellants in these appeals approached the High Court by filing writ petitions for quashing the select list of the candidates published by the authorities in the Tribune dated so and so, for issuing writ of mandamus directing the respondents to consider their claim on the basis of their merit from amongst the candidates originally invited for interview, and to issue a writ in the nature of prohibition restraining respondents from giving effect to the selection made. It may be mentioned here itself that the selected candidates were appointed on so and so, and having joined the services, they are continuing in service. The High Court, considering the rival contentions on the relevant merits and after perusing the records, did not find any merit in the writ petition. Consequently, they were dismissed by the impugned order. Now, this is the background, similar, my lord, to our case. And in this background, Lord, the court comes to this finding. Kindly, my lord, turn to now, my lord, the facts are being discussed in different paragraphs. Relevant ratio comes, my lord. Paragraph 14, again, my lord, 15. The earlier judgments are discussed. I am not troubled, my lord. Kindly come to paragraph 16. Also, it's not necessary. This is also the other judgments. So may I please note the paragraph 20. The learned single judge, well, this is quoting from the earlier judgment also seems to have been very much carried away by few instances noticed by him as to the award of higher percentage of marks in the viva voce to those who got lower marks in the written test as compared to some who scored higher marks in the written examination but could not get as much higher marks as in viva voce. Picking up a negligible few instances cannot provide the basis for either striking down the method of selection or the selections ultimately made. There is no guarantee that the person who fared well in the written test will be presumed to have fared well in the viva voce test also. The expert opinion about as well as the experience in viva voce does not lend credence to any such general assumption. In all circumstances, and for that, that apart, the variation of written test marks of those who were found to have been awarded higher marks in the viva voce, those who secured higher marks in the written test but not so in the viva voce cannot be said to be so much as to warrant any proof of inherent vice. This is the point which I want to emphasize. As to warrant any proof of inherent vice in the very system of selection or the actual selection in the case. There is no specific allegation of any malafidis or bias against the board constituted for selection or anyone in the board, nor any such plea could be said to have been substantiated in this case. The observations by the learned single judge that there was a conscious effort made for bringing some candidates within the selection zone cannot be said to be justified from the mere fact of certain instances noticed by him on any general principle or even on the merits of those factual instances alone. Further, the course adopted by the learned single judge in directing selection from general candidates of all those who have obtained 56 marks in the written examination cannot be justified at all. And it is not given to the court to alter the very method of selection and totally dispense with the viva voce in respect of a selection alone of the candidates for purpose of selection. On a careful and overall consideration of the judgment of the single judge and that of the division bench, we are of view that decision on a single judge cannot be sustained for the reasons again assigned by him, and the decision of the division bench cannot be considered to suffer any such serious infirmity in law to call for further interference. The learned counsel for the appellant asked an additional ground that 5 marks fixed for the higher education and additional qualification of MA LLB ought to have been given additional marks, but only 2 marks were given, both the qualifications together, which affected his chance selection. It appeared that this point was not asked before the High Court, and so opportunity was given to the respondent to meet this point. However, during the course of hearing, based on the criteria fixed for selection, it was explained to us by learned counsel for the respondent that for additional educational
I
qualification,
believe it is not necessary.
These are not-
Basically,
these are not
I believe
basically
it, there was no specific allegation of any malafide bias against the board constituted for selection of anyone in the board or not any such plea could be said to have been substantiated in this case.
2 examinations.
So I
held.
believe this portion is pertinent for you.
That is the pertinent, absolutely. And not in the background, there are 2 examinations held. That is the that's why I placed the first paragraph to show that even if 2 examinations are held, unless
No, 2 examinations not held. 2 results have been published, lowering the standard.
No, 2 examinations are held.
Huh?
2 separate examinations are held.
Like কি?
Para 11, I think.
Third नहीं लगेगा
To be examination held. No.
May I just place below the
Just a minute, sir.
issue?
First paragraph.
These appeals are directed against the common judgment so and so. Then a written test was conducted
A written test.
on 24th March 1996.
Huh.
The result of which was declared on 1st April,
Huh.
declaring 78%.
Successful.
Later on, 2nd April 1992, for 40 more can declare successful by lowering the standards.
Huh. So one test, two result.
Right. That is right. One test, two results. There also the Supreme Court does not interfere, saying unless you can show
Here two tests, one result.
one result. And that result, is the preparation of combined merit list.
I'm sorry. I believe your bone contention is lies that there was no specific allegation of malafide bias against the board constituted for selection or anyone in the board, nor any such plea could have been said as substantive. That is the point.
The crux of the
That
whole
is the crux here.
legal issue, and particularly in view of the statutory rules that everyone has to be examined. And everyone was examined. This was the bounden duty of the statutory authority.
Anything more, Mr.
But these are all no normalization. No, বলে দিয়েছি. Now here,
then what is the prayer of your clients?
appointment should be given. That is the most basic prayer. সেটা চাইছি আমি,
You are adopting the argument. You have a separate footing.
এটা করেছেন স্যার আর আনসাকসেসফুল দেওয়ার দরকার নেই এটারও দরকার নেই
Normalization.
So your stand is different from the clients of Mr. Bhattacharya.
Our position is different, but stand will be same. My logic will be different.
Very good. Tomorrow is the date, no?
না পরশু দিন আছে
30 তারিখ আর 1 তারিখে আছে আসুন নোট করে নিন
Participating.
My lord, I am led by Mr. Mojumdar. Mr. Mojumdar asked me to request your lordship for 2 p.m. for tomorrow. He has
10:30 10:30
for any other day, my lord, 2 p.m.
No,
if
sir,
your
I
lordship-
cannot. Already fixed, sir. Sir, I have
My lord, I am for the (103). I am for the private respondent. My lord, in 103, I am for the private respondent.